Welcome! Hi everyone! Welcome to the pilot episode of this YouTube channel. Yes, featured here is the discussion on Rule 66 of the Rules of Court by Group 2 of the Special Civil Action and Provisional Remedies Class 2022 of Manila Adventist College School of Law and Jurisprudence. Now, how do we define Quo Warranto? Rule 66 does not give us the definition. However, case law does. In the case of Texon versus Comelec, it mentions that Quo Warranto literally means by what authority. It is a prerogative writ where the court can call upon any entity to show his authority to hold a public office or exercise a public franchise. Also, in the case of Defensor Santiago versus Gingona, a Quo Warranto proceeding is defined as the proper legal remedy to determine the rights or title to the contested public office and to oust the holder thereof from its enjoyment. Let's check other proceedings and see the difference of these proceedings to Quo Warranto. First, how is Quo Warranto different from mandamus? As we have just mentioned, a Quo Warranto is the remedy to determine the right or title to the contested public office and to oust the holder thereof from enjoying the same. On the other hand, according to the case of Lota versus CA, mandamus enforces clear legal duties, not to try disputed titles. How about Quo Warranto against election protest? How are they different? Quo Warranto refers to questions of disloyalty to the state or of inability of the winning candidate, whereas election protests, according to the case of Lokin Jr. versus Comelec, proposes to oust the winning candidate from office. The basis of the protest is electoral fraud and irregularity, and the result of the protest determines who, between the losing and the winning party, actually obtained the majority of the legal votes cast and is therefore entitled to hold the office. How about the difference of Quo Warranto from impeachment? We have to see three things, or take a look at three things. One is authority to try. Section 5, Article 8 of the Constitution provides, in part, that the Supreme Court shall exercise original jurisdiction over petitions for Quo Warranto. On the other hand, Article 9, Section 3, Paragraph 1, and Section 3, Paragraph 6, respectively, provides that all cases of impeachment will be initiated by the House of Representatives, while it is the Senate that shall have the sole authority to try and decide them. Number 2, the nature of proceedings. In a Quo Warranto, it is a judicial proceeding, while in impeachment, it is a political proceeding. Number 3, the reliefs sought. In Quo Warranto, when the respondent is found guilty, he or she shall be adjudged to stop occupying the office, or because he or she is ineligible to occupy the same. In impeachment, as in the case of the Republic of the Philippines versus Maria Lourdes Sereno, when one is proven to have violated an impeachable offense, the respondent shall be removed from the public office that he or she is legally holding. Now, what is the subject matter of a quo warranto? Rule 66, Section 1 provides that quo warranto is an action for the usurpation of a public office, position, or franchise. Still, in the case of Sereno, it was mentioned that in offices filled by election, quo warranto determines the eligibility of the candidate elected, while in offices filled by appointment, what is determined is the legality of the appointment. However, let's note that the Supreme Court also declared that quo warranto may not only refer to claims of ineligibility, but it extends to other instances or claims of usurpation or unlawful holding of public office. Against whom may we bring an action of quo warranto? Section 1 provides that, and it provides 3 entities against whom an action can be filed against. 1, a person who usurps, intrudes into, or unlawfully holds or exercises a public office, position, or franchise. Section 2, Article 9 of the Constitution allows that a quo warranto action can be instituted against an impeachable officer. In the Sereno case, it was mentioned that the quo warranto petition is predicated on grounds distinct from those of impeachment. The former questions the validity of a public officer's appointment, while the impeachment was a result of indictment from impeachable offenses without questioning title to the office held. Number 2, a public officer who does or suffers an act which is prohibited by law and therefore is a ground for forfeiture of office. Or number 3, an association or firm which acts as a corporation within the Philippines without being legally incorporated or without lawful authority so to act. We ask, who may commence a quo warranto action? There are 2. Per Section 3, Rule 66 of the Rules of Court, the first entity who can commence an action of a quo warranto is the Solicitor General, the Solicitor General or Public Prosecutor. Second, according to Section 5 of the same rule, any person who claims to be entitled to a public office or position which was usurped, unlawfully held, or exercised by another person. When can the Solicitor General or Public Prosecutor commence a quo warranto? Section 3 of Rule 66 provides 1. When the President says so. 2. When a complaint is received by the Solicitor General or Public Prosecutor and they have good reasons to believe that a case may be filed and it can establish proof. Third, when the court permits the quo warranto, the officer bringing the action needs to require an indemnity for the expenses or costs of the action. The court will determine the amount, and the same will be deposited to the court. When can an individual commence a quo warranto action? Section 5 provides when there is clear showing that a person has entitlement to a contested office, the person claiming the said public office or position usurped or unlawfully held or exercised by another may bring the action under his own name. It should be noted that this person cannot just assert or say that he is the preferential candidate to be appointed. In other words, mere preferential right does not qualify as a ground to institute an action of Quo Warranto. That was mentioned in the case of Topacio versus Ong. Also, in the case of Koyageng versus Cruz, it was mentioned that mere assertion of a right to be appointed to the office is not sufficient regardless of the alleged flaws in the title of the respondent. Where to file this Quo Warranto petition? It can be brought only in the Supreme Court, the CA, or the RTC exercising jurisdiction over the territorial area where the respondent or any of the respondents reside. But when it is the Solicitor General filing the action, it may be brought in RTC court in the city of Manila, 1, 2 in the CA, and 3 in the Supreme Court. That is according to Section 7, Rule 66 of the Rules of Court. What is then the period or the time range for filing Quo Warranto? The action must be commenced within 1 year, reckoned from the date of the ouster or the date of the petition to hold such office or position arose. That's according to Section 11, Rule 66. It should be noted, though, that under Section 8, the court may reduce the period of filing pleadings and all other proceedings to get the most expeditious determination of the matters involved. So it doesn't have to be a whole 1 year for the commencement of the action. Also, the action for Quo Warranto may be given precedence over any civil matter pending in the court. So what does the petition for Quo Warranto include? The petition shall include, first, the name of the person claiming entitlement to the post. Second, any statement or facts or circumstances of his right to the post and that the respondent is unlawfully in possession of that post. Number 3, all persons claiming entitlement to the post and their respective rights thereto in the same action. What's the prescription and when shall it apply? It will apply when the petition was filed by the state through the Solicitor General. Number 2, when the Solicitor General or the public prosecutor, at the request of the filing party, with leave of court, except when there's established jurisprudential exception, are present. Number 3, when filed by an individual under his own name, prescription shall apply. except when there are established jurisprudential exceptions present. Now, what are these jurisprudential exceptions? These exceptions happen when, first, the petitioner did not silently consent to the taking of his rightful office or abandon his right or possession thereto. Second, when it is the government that contributed to the delay in the filing of the action. Number 3, and the last, when the petitioner asserts his or her removal from the questioned position is contrary to law, as in the case of Republic versus Sereno. Notice of hearing, as mentioned in Section 4, still of Rule 66. The court shall direct that notice be given to the respondent so that his opposition can be heard. Also, if the petition is granted, the court will issue an order and copies will be served to all interested parties, and the petition will then be filed within the period the court ordered. Judgment in Quo Warranto proceedings. 1. When the respondent is found guilty of usurpation of a public office, as provided in Section 9, and when the person averred in the complaint is actually entitled to the public office, as mentioned in Section 10. When it is found out that the respondent is found guilty of usurpation of public office, that person shall be 1. Ousted and excluded from the office. 2. The petitioner or relator shall recover the cost of action. Also, the petitioner will be entitled to such other judgment determined by the court, respective of his rights in the public office and all the parties to the action as justice requires. We should note that the court may render judgment for costs either against the petitioner, the relator, or to the respondent, or the person or persons claiming to be a corporation. The court may also apportion the costs depending on justice. This is mentioned in Section 12, still of Rule 66. What about when the court finds out that the person complained of is actually entitled in the public office? What will happen is that the person can then take the oath of office after executing the required bond. He will then exercise the power of the office he now holds. Also, he will immediately demand from respondent to surrender any books and papers in his custody related to the office that he once held, per Section 10. And then he will recover the damages sustained by him from the usurper. If the respondent refuses or neglects to deliver any book or paper pursuant to such demand, he may be punished for contempt because of disobeying a lawful order of the court. Rule 71, Section 31, Paragraph B of the Rules of Court provides that disobedience to a lawful order causes indirect contempt. This contempt is punished after a charge in writing has been filed and an opportunity is given to the respondent on why he made why he disobeyed the order. This wraps up our report. Thank you so much.